Today we're doing a Radio Row. We're going to have a variety of guests on the topic of what's going on before the Supreme Court right now, which is the debate about Obamacare and the so-called Affordable Care Act, and the so-called Obamacare. Actually, it's technically called the Affordable Care Act. And before we get into the details and the nitty-gritty of that, and a lot of our guests are going to do that, I wanted to talk with you about the whole idea of the Supreme Court making such a decision in the first place. This is a court that has gone off the rails. But here's the thing, the amazing thing, is it hasn't just gone off the rails recently. It went off the rails 1803, 1903, over 200 years ago, in 1803. The Supreme Court, by declaring that they have the power to strike down laws passed by the president, has basically set themselves up as kings and queens, and nowadays, back in the day, it was just kings for this country. Did the founders intend that 9 people on the Supreme Court, it's been various numbers at various times, it's been 7, it's been 5, but right now it's 9 people, that 9 people on the Supreme Court, did the founders intend that 9 people on the Supreme Court should have the power to strike down laws passed by Congress? Did the founders intend that Congress should have the Supreme Court should have the power to strike down laws signed into law by the president? Actually, no. Not at all. This was debated in 1787 at the Constitutional Convention, and they explicitly decided not to give that kind of power to the Supreme Court. In fact, in Federalist Number 78, 1788, these were the papers, the Federalist Papers were written by John Jay, mostly by Alexander Hamilton and James Madison, and a few by John Jay and George Mason. And they were basically a sales job. They were trying to sell the Constitution to the American people. It took 2 years, from 1787 when it was written until 1789 when finally they had gotten ratification by enough states that they could say, okay, we've got a new country, and George Washington's going to be our president. And that was in 1789, 2 years later. So in 1787, 1788, they published these series of what we call the Federalist Papers now. Back then, they were letters to the editor signed by Publius, by an anonymous source. And from Federalist Number 78, here's what Alexander Hamilton wrote when reassuring the American people that the Supreme Court would never have the power to strike down laws, that the power to make laws would always reside with the lawmakers who are answerable to we the people. You can throw a lawmaker out on his butt. It's called an election. You can't throw a Supreme Court justice out on his butt, and that worried a lot of people. And they wanted to make sure that the Supreme Court was only the final appeals court, and that's it. In Hamilton and Federalist 78, you can read it yourself, he wrote, "The judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be the least in a capacity to annoy or injure them. The judiciary has no influence over either the sword or the purse." What he's talking about there, the sword, of course, is the executive branch. That's where all police functions are and military functions are. And the purse, of course, is Congress. Only Congress can appropriate or spend money or raise taxes. It's right there in Article 2, the executive branch, Article 1, the legislative branch of the Constitution. So anyhow, Alexander Hamilton says the judiciary, which is Article 3, the third of among equals, but actually the inferior of them. He says the judiciary has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society. In other words, they can't mess with our money. They can't make decisions like they're trying to make today, and can take no active resolution whatever. In other words, they can't make laws. It proves, Alexander Hamilton wrote in 1788, it proves, a year before we became a nation, it proves uncontestably that the judiciary is beyond comparison the weakest of the 3 departments of power, semicolon, that it can never attack with success either of the other 2. So the Constitution says that the Supreme Court is the final court of appeals. So like if AT&T and Verizon had a series of lawsuits that went all the way up through the courts until they finally, somebody finally has to say, okay, this is the final decision, end of the road. That's the Supreme Court. That's the role that the Supreme Court is given in the Constitution. That's it. And even that capacity can be regulated by Congress. As the Constitution says, Article 3, Section 2, you can read it in the Constitution. The Supreme Court shall have appellate jurisdiction, right, final appeals court, both as to law and fact, with such exceptions and under such regulations as Congress shall make. In other words, they are subordinate to Congress. So how did they get the power to strike down laws and stop presidents? To become the unelected kings and queens of America? They took it onto themselves. In 1803, in a case called Marbury versus Madison, when Chief Justice Marshall announced that case, then President Thomas Jefferson went absolutely nuts. He said, as the Federalists say, the judiciary is the last resort in relation to the other departments of government, then indeed is our Constitution a complete felo de se, which is Latin for a suicide pact. He said, the Constitution on this hypothesis is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they may please. End of quote. But Jefferson couldn't contest that case because he had won it. Marbury versus Madison. James Madison was Jefferson's Secretary of State. Jefferson was the president in 1803. He won the case. You can't contest a case before the court that you just won. So he was stuck with it. It was like John Marshall figured out a way to get Jefferson and the nation. President Andrew Jackson, over the next 50 years, by the way, this was only used about a half a dozen times because of the public blowback. Andrew Jackson, for example, in 1832, this is 50 years into our republic. The Supreme Court, and again, this was John Marshall. He was still on the bench. John Marshall ruled that the state of Georgia couldn't seize Indian lands, and the state of Georgia was actively doing it, and the president, Andrew Jackson, was totally in favor of it. And so he said, and I quote, Chief Justice John Marshall has made his decision, now let him enforce it. And he just completely ignored what the Supreme Court said. Lincoln took on the Supreme Court. Franklin Roosevelt took on the Supreme Court. As Newt friggin' Gingrich pointed out. Clip number 3, Jacob. This is Newt Gingrich talking about this.
I'd ask, first of all, have they studied Jefferson, who in 1802 abolished 18 out of 35 federal judges? 18 out of 35 were abolished.
Something that was highly criticized.
Not by anybody in power in 1802. Jefferson himself is asked, is the Supreme Court supreme? And he said, that is absurd. That would be an oligarchy. Lincoln repudiates the Judge Scott decision in his first inaugural address in 1861 and says, no 9 people can make law in this country. That would be the end of our freedom. So I would suggest to you, actually, as a historian, I may understand this better than lawyers. And as lawyers, those 2 attorneys general are behaving exactly like law schools, which have overly empowered lawyers to think that they can dictate to the rest of us.
And he's absolutely right. It pains me to say, Newt Gingrich is right, but he is. And he's not alone. This isn't a left or right thing. The dean of the Stanford Law School, a fellow by the name of Larry Kramer, has written an entire book about this called The People Themselves, which was the phrase Jefferson said. After this Marbury decision, Jefferson said the power should be with the people themselves, not with the Supreme Court, to decide what is and isn't constitutional. If Congress passes a law that the people think is unconstitutional, they vote that Congress out, and a new Congress comes in and repeals the law. That's the remedy. And that's what Abraham Lincoln was calling for when he said, the Supreme Court should not have decided Dred Scott, should not have decided in 1856 that people are property, leading right straight to the Civil War.